Everybody. Yeah. Good afternoon, everybody, and welcome to the 2022 webinar of the Nigerian Bar Association Section of Business Civil Aviation Committee. The theme of this webinar is highlights of the Civil Aviation Act 2022. As a background, the Civil Aviation Act 2022 was enacted into law this year, and it repealed the 2006 Civil Aviation Act, which was a revolutionary statute in Nigerian civil aviation regulation. The purpose of this webinar is to highlight the new innovations and development brought about by the 2022 Civil Aviation Act, and to help or to assist us in this discussion in highlighting this new development is a panel of distinguished experts and professionals in their own right. And because of time, the paucity of time, I'll do a very brief introduction of each and every one of them. I'll start by introducing the learned silk among the panelists in the person of Mr. Ajibola Dali. Mr. Ajibola Dali is the managing partner of GRF Dali, one of the foremost law firms in Nigeria. He is a fellow of the Chartered Institute of Arbitrators of Nigeria. And also, Mr. Ajibola Dali has a vast experience in transportation practice, in banking and finance, especially when I mean transportation practice, I mean aviation practice in particular. Mr. Ajibola Dali, I welcome you to this webinar.
Thank you very much. Thank you for inviting me.
You're welcome. Then, second on the panel is Mrs. Chinasa Unebunam. Chinasa Unebunam is the managing partner of one of the foremost law firms in Nigeria, Stream Sowers and Co. Chinasa Unebunam is the chair of the Aviation Committee of the MBA section on business law. She's also a fellow of Chartered Institute of Arbitrators of Nigeria. Ms. Chinasa Unebunam was the co-counsel for the drafting of the Revolutionary Civil Aviation Act 2006. And also, she participated in the drafting of the declaration made portion to the Cape Town Convention. Ms. Chinasa Unebunam, you are also welcome to this webinar.
Thank you. Thank you, Rafi.
You're welcome. And lastly, but not the least, is Mr. Emmanuel Dubem Chukwuma. Mr. Emmanuel Dubem Chukwuma is the legal advisor, head, compliance and enforcement of Nigeria Civil Aviation Authority. Mr. Chukwuma was the former Attorney General of Anambra State, and also a former legal special assistant to a Minister of Aviation in Nigeria. Mr. Chukwuma was member of the committee that produced the National Civil Aviation Policy of 2013, and he also took part in the review of the Civil Aviation Act 2006. Welcome also, Mr. Chukwuma, to this webinar.
Thank you, Rafik.
You're welcome, sir. So you all agree with me that we have very competent and distinguished members of this panel who are very competent to give us or to highlight and discuss the key points in the Civil Aviation Act 2022, especially those areas that have agitated our minds as practitioners, legal practitioners, and as practitioners in the civil aviation industry in Nigeria. So without taking much of our time, I will start by asking the panelists specific questions for their responses. I will start with Mr. Ajibola Dali. No, let me start with Mr. Chukwuma, because Mr. Chukwuma is part of the regulators. He's head of compliance and enforcement, so he knows all about the Civil Aviation Act 2022. So I will start with him. So Mr. Chukwuma, There are 118 sections in the Civil Aviation Act 2022, while there are just about 74 sections in the CAA 2006. So there must be a lot of additions to the CAA 2022. Please, can you highlight to the audience the major innovations introduced by the Civil Aviation Act 2022?
Thank you, Rafik. First of all, I'd like to give a short background as to what led to the review in the first place on 2006 Act. Number one, there were audit findings. You know, Nigeria as a member state of ICAO, we get audited now and again to evaluate our capacity for oversight of civil aviation. So in one of those audits of 2016, there were some findings, principally that the Establishment Act of Service Provider Agencies, FAN and NAMA, contain regulatory powers and functions, which should not be. And there were also some omissions that were pointed out, and some of the text of the 2006 Act were not quite explicit. Then the second reason for the review is that we needed to update so as to include new developments and innovations in international civil aviation. And lastly, we also needed to address lessons that we learned over the years from the implementation of the 2006 Act. What I have done is that I prepared a PowerPoint where comparison of the 2006 Act and the 2022 Act, so as to bring out clearly what innovations, to use your word, what changes we have made, and then try to explain why we had to make these changes. So if you allow me to share my screen, let me project my PowerPoint.
Yeah, feel free to do that, sir.
Okay, thank you. Are you seeing me?
I can see you, but I can't see your screen.
Okay. Are you seeing the screen now?
Yes, sir.
You're seeing it now?
I can see it.
Okay, okay. All right, the first change we made was in our name. We used to be the Nigerian Civil Aviation Authority, but we have now changed it to Nigeria Civil Aviation Authority. It may sound cosmetic, but that is the way ICAO refers to member states. Nigeria CAA, Ghana CAA, not Ghanaian CAA, Kenya CAA, not Kenyan CAA. So we wanted to flow with the tide by changing our name to Nigeria CAA instead of Nigerian Civil Aviation Authority. That's the first change we made. We also addressed the finding about the service provider agencies having regulatory functions by introducing this section 8.3, which says that the NCA shall solely be responsible for the regulation of civil aviation in Nigeria, whatever is contained in any other law. That, in our view, should address for now and in the future any incursion into the regulatory authority of the CAA by service provider agencies. We also introduced this section 8.1J, which gives us responsibility to issue rules and regulations on aviation environmental protection. There is it's a new thing that ICAO is handling. You may have heard of COSIA, the Carbon Offsetting and Reduction Scheme for International Aviation, which is an ICAO initiative to address CO2 emissions, and Nigeria has keyed into it. So we needed to give ourselves the legal framework to be able to participate actively in that ICAO initiative. So this is a new innovation. Then this is also, the search and rescue bit is also to address an audit finding that Section 30, subsection 3, paragraph 0 of the 2006 Act did not quite explicitly state what is required in search and rescue. So we have amended it in Section 9 of the 2022 Act to put in details what we are required to do for aircraft in distress in search and rescue. Then we have also changed the name of our Director General. There are other Director Generals in civil aviation, other service provider agencies, and we wanted to emphasize the fact that the DG of NCA is the Director General of Civil Aviation. That is also the way ICAO refers to them. ICAO calls them DGCAs, Directors General of Civil Aviation. So we also wanted to flow with the tide and to emphasize the fact that the NCA is the sole regulator of civil aviation in Nigeria. Therefore, the Director General should be properly addressed as the Director General of Civil Aviation. Then we have introduced Section 11, subsection 3, to give security of tenure to the holder of the office of Director General of Civil Aviation. This is a lesson from our experience where one of our DGs was removed after 6 months in office for reasons we don't know up to today, just removed, whims and caprice of whoever of the minister at that time. So we didn't want that to happen. We feel that the security of tenure will enable the holder of that office to focus on the very, very important responsibility of ensuring safety, security, and efficiency of civil aviation. So we have made his removal subject to confirmation by the Senate. The 5% charge that passengers pay is our mainstay of our revenue. We've been having a lot of problems with the airlines with respect to this, because the 2006 Act statutorily says that it shall be collected by airlines and paid over to the authority. Our experience has been that the airlines collect but do not pay over. And since that revenue, that fund constitutes of up to 90% of our funds, we felt that we should not let that situation stay. There is an airline that is in receivership that, according to our books, failed to remit as much as 19 billion collected from this 5% charge. And you know what that means for the carrying out of our functions. So we have changed it now and retained the charge, explained it that it's payable on international and domestic air transportation originating in Nigeria, irrespective of place of issuance of tickets or the execution of the contract. And we have now made it discretionary. The delegation now is, the authority may now delegate that power to airlines. So if you are an airline that is up and doing and you're remitting, we will formally delegate to you the function, to the power to collect. But if you are one of those airlines that collect and do not remit, NCA will now have to collect it ourselves. I will talk on the consequences later, because it certainly will have some disruptive effect on facilitation, particularly the burden, if we are to send our people there to collect the 5%. But we'll talk on that as we progress. Then we have also criminalized non-remittance. This was a very contentious issue during the public hearing, but at the end of the day, the aviation committees of both Senate and House of Reps saw with us the need to have this section 23, subsection 10. When we presented to them the humongous amount collected and not remitted, and we are just like, we are helpless, there's nothing we can do. So we decided, so it's now been criminalized, and any air operator who fails to remit within the time specified in the regulations commits an offense. and is liable on conviction to the stated imprisonment and fine. The 2006 Act, Section 29, Subsection 1, established the AIB, the Accident Investigation Bureau. It's now been deleted. The AIB will now have to have its own law, or has its own law. I don't know whether they are in the process of having their own law. For the time being, we have deleted this section that established AIB. So AIB is no longer established under the Civil Avaiation Act. We have introduced this section to enable us react immediately, without hearing, without notice, when we are faced with an emergency situation. This is introduced to enable us deal with emerging threats, security threats, so that we'll be able to, or safety issues, security and safety issues, so that we'll be able to react immediately without going through the process of establishing that there is indeed a safety issue. Section 37, subsection 1, it's an audit finding that we needed to protect safety data. It's an audit finding which we are closing here by providing that we shall not make available or use safety data for other purposes, except for safety-related purposes. There's an exception there where it's determined that the impact of the disclosure outweigh the adverse impact of such disclosure, then it can be disclosed. This is an audit requirement of ICAO. Exemptions, this is also another audit requirement. The way the 2006 Act is, the text seems to look like persons and aircraft shall be exempted, but that's not the idea. The exemption is supposed to be an exemption from compliance with the requirement of the regulations. So we have changed the text to explicitly bring out the purpose of exemptions. There are regulatory requirements, and if an operator is unable for whatever reason to comply with that, it can be exempted from compliance with that regulatory requirement, but it must not compromise safety and security, and it must be in the public interest. So that has been explicitly stated in this amendment. Then this is a new thing. This is an update. There's a scheme of going on now about the advanced passenger information, API, and passenger name record. It's a security thing. The idea is that the airline sends to the destination country ahead, before the aircraft departs, information about the passengers on board. The destination country now uses that information to check whether there are persons of interest. It's part of the fight against terrorism. So that by the time the aircraft now arrives at the destination, I don't know whether you have experienced it in your travel, security will just walk into the aircraft and pick up somebody. This is the product of this API. Nigeria is supposed to participate in it, but we do not have the legal framework. So this is to give Nigeria the legal framework to participate in API and PNR. This is also a security issue. There are at least I know one of our bilaterals with the US, yes, our PASA with the US, it is open skies. There is a provision there for air marshals. They are called air marshals. And in our ongoing discussion with Israel, the state of Israel, about our PASA, there's also going to be a provision for air marshals. They are armed security persons who bought the aircraft. Nobody knows that they are, but they're supposed to take care of security and security issues that may arise. So we are trying to give ourselves legal framework to define the standards for deployment of persons on board for security purposes, that's air marshals. Then this is also to deal with emerging security issues. Security is top burner now in view of what is happening all over the world, not just in Nigeria. So we have included updated provisions of dealing with security to enable us react to emerging security situations. Then this is a mandatory occurrence reporting. We have expanded it to include voluntary and non-punitive reporting because our inspectors cannot be everywhere at the same time. So we need information from members of the public, and we have expanded it to include incidents involving not just aircraft, but at aerodromes. It's also security related. This is also to give us, this amendment is to give us what is there initially is free and unobstructed access to enable the inspectors carry out their work. We have now expanded it to free, unrestricted, unobstructed, and unlimited access. We need this access to be able to carry out our inspections and investigations. And I think section 48, subsection 3 or 4 expanded it to even beyond the airport environment, to grant access to inspectors to carry out their inspection beyond the airport environment. And there's section 49(1). Previously under the 2006 Act, before we can stop a flight or ground an aircraft, we have to have the facts that there is indeed a safety issue. Right now, this section 49(1), what it does now is that even if we have not yet established that there is a safety issue, but we have information that there's going to be a safety issue if that flight is operated. We now have the power to direct that aircraft not to operate. If the aircraft may not be, as the aircraft may not be airworthy, that's why we use the word may not. It may be airworthy, it may not be airworthy, but we don't want to take the risk of trying to find out. If we allow the aircraft to operate and something happens, then we got information that this aircraft may not be airworthy. So we stop the flight, stop the operation, and ascertain whether the aircraft is airworthy before we let it continue. And also it also applies to the airman.
Sorry to Mr. Chukuma, sorry to interrupt you. Because of the paucity of time, I know that you have a lot to say on this point because this is the main focus of this webinar. But maybe I'll give you another 2 minutes to round off on this point before we go to the next question.
Okay, thank you.
Okay.
This slide, we have been, under section 12, subsection 1 of the Constitution, for any treaty that Nigeria is a party to become applicable in Nigeria has to be what we call domesticated. So rather than wait for the National Assembly to go through the process of domesticating each other, we have domesticated them by reference. So this one has increased the number of conventions Nigeria has ratified that have now become domesticated. We charge right now, international passengers pay security surcharge, but there is no legal framework for it. This section 51 gives the legal framework. Under Article 83 bis of the Chicago Convention, we can delegate some functions to other member states, and we can accept some functions. In the 2006 Act, unfortunately, Article 30, aircraft radio equipment was omitted. So this is just to fill up what was omitted. Then under Article 24(1) of the modified Montreal Convention of 1999, which applies to domestic travel, there ought to be a review after 7 years of the amount of compensation paid. It has never been done. So what we have now done is to introduce it so that the review will be automatic, instead of waiting for the Honorable Minister of Aviation to do the review. It just kicks in automatically. Once ICAO does its own review after 5 years, we automatically do our own review. That increases the amount of compensation payable in the event of death or accident. We record interest in aircraft mortgages today, but there is no legal framework for it. So this takes care of it for us.
Okay, thank you, Mr. Chukuma.
Thank you.
On this point, maybe I know there's still a lot to say and there's still a lot to highlight. Maybe you could make your slide available to anybody who's interested to get in it, maybe to the council, to the committee. Anybody who's interested to have it can reach out to the committee, then we'll give it to, because I can see it is well loaded, really. It is a very detailed slide. And I'm sure a lot of people will be interested in what you have there. But because of time, we have to move to the next question.
Okay.
And the next question is also for you. Yes. The next question is also for you. Now, from a safety and regulatory perspective, all these innovations that have been introduced by the Civil Avaiation Act 2022, why are they necessary?
I have, in explaining why the amendments were made,
Yes.
attempted to answer those questions. I was giving reasons why we had to. So that answers the question. But the overall effect is that we are trying to have a very robust, autonomous, independent CAA that is equipped, at least by a legal framework. It is equipped to effectively carry out oversight. Safety, 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 safety. So these amendments will address any lapses and any shortcomings in the Civil Aviation Act, and the result will be a very robust CAA, very robust Civil Aviation Authority, well equipped legally with the appropriate legal framework to carry out those functions of ensuring safety, security, and efficiency of civil aviation in Nigeria. Thank you.
Okay. Thank you, Mr. Chukwuma. Now, the third question I would like to ask Mr. Daly. I don't know if Mr. Daly is still with us. Okay. So, Mr. Daly.
Yeah.
Oh, good. Now, would you say that these innovations that Mr. Chukwuma has highlighted have addressed the shortcomings of the Civil Avaiation Act 2006? From your point of view?
Yes, they've highlighted a lot of the issues that arose, and a lot of those amendments or additions that have been made not only introduce fresh, if you like, statutory or regulatory provisions that cover the lapses that existed over the past. Don't forget that the last time the law was brought into place was in 2006, almost as a matter of urgency because of the air crashes that occurred in the 2-3 years prior to that. So I think the 2006 Act was perhaps, I don't want to sound ungrateful, but a rush job in the sense that it needed to address security and safety oversight more than anything else as a matter of urgency. So the other provisions that ought to have been put in place, which are now being covered by the 2022 Act, I think has sort of been very helpful. It is indeed a very robust legislation. My only concern is that sometimes I look at legislation or an act, should an act be this robust, a lot of the provisions ought to be by way of regulation, I think, because it's a fluid, an act cannot really cover every single incident that occurs. I understand that perhaps the drafters of this legislation, because of the challenges we have in Nigeria in terms of implementation and enforcement, saw the need to create a nuanced approach to legislating, which means that where you have regulators in perhaps other systems enforcing broad broad statutory provisions, in Nigeria, you always have a challenge. There's always one challenge or the other. A lot of the times, even us lawyers are part of the problem, where a regulator has a dynamic approach to enforcing statutes. They would oftentimes be challenged and saying it's not in the act, it's not in the act. And I think that is why we see a very robust legislation to deal with those kind of issues. It's almost as if every single scenario that can be imagined is being put into this act. So for the purposes of a nuanced approach, what we face in Nigeria in terms of regulation, I think it's a very welcome piece of legislation. And I think it's almost as if every possible challenge that might be foreseeable by the regulatory authority, by the NCA, will now be addressed. Having said that, I think there are one or two issues, and I say one or two because I don't want to sound ungrateful, that ought to have been considered in the legislation. I think we as the members of the legal profession put under the MBA and our committee, we had put together a proposal to also include the fact that the Federal High Court should have jurisdiction in respect of claims, civil claims, and that was outrightly ignored by the legislature, by the National Assembly. And it was something that was important for us because it was a problem. It's a problem that has continually, in terms of enforcement, a lot of the times when civil suits are filed at the Federal High Court, some justices of Federal High Court will say that it's not the Federal High Court that has jurisdiction, and then you end up going to the Supreme Court.
Sorry, you mean by
Yes.
civil suits, you mean aviation-related civil suits?
Yes, of course, aviation-related civil suits. There's sometimes confusion. I mean, those of us in the aviation space know that the Federal High Court, under the Constitution and under the Federal High Court Act, has exclusive jurisdiction to deal with claims, civil claims in aviation-related matters. It's broad enough, but for some reason or the other, some justices of the Federal High Court, even the State High Court, and even the Court of Appeal have a different view. And we felt that this is the one single piece of legislation that for us was missing as lawyers. I think it ought to have been included. And that is the only challenge that I would have put to the legislators, that we presented and it was ignored. Since we are putting everything into the act, why didn't we put this one? But by and large, the act, in my view, is robust, and I am happy about the fact that it's covering a lot of the issues that occur on a regular basis, which the regulators have challenge with. So we're happy with it generally.
Okay, thank you, Mr. Dali. Now, Mrs. Unebunam, Mr. Dali has agreed with Mr. Chukuma that the Civil Avaiation Act 2022 is a robust act. And he has pointed out one shortcoming in his own view, which is the exclusion of the provision that he would have loved, vesting exclusive jurisdiction in aviation-related civil claims on the Federal High Court. Now, from your perspective, are there other shortcomings that you think that this new act has? It's 2022 Civil Avaiation Act.
Thank you again. For me, I think Mr. Chukuma has mentioned one. I think maybe it was an error or inadvertent that the AIB, the provision relating to the AIB was excluded from the act. I know that when the amendment was being made, or when the repeal and discussion in relation to the bill was ongoing at both at the National Assembly, there was the plan to amend most of the other regulatory agencies, the laws in relation to most of the regulatory agencies. And people in the space understood that those laws will be passed together because they were mostly intertwined. There was some relationships with most of them. One of them was a proposed bill trying to establish some investigative body for the entire civil transportation sector. And the duties of the AIB was moved on to that to that proposed bill. But unfortunately, when the Civil Aviation Act of 2022 was passed, that law hasn't come to fruition. And it's, for us, I think it's a big, it's a gaping hole. And in addition, you can see that the law itself, the provision relating to the distribution of the funds for the accruing from the ticket sales charge, in fact, still recognized and increase the percentage that is supposed to go to the AIB from 3% to 6%. So that for me was it's going to cause a lot of issues in relation to interpretation, in relation to the current AIB now. People can argue that, look, there's even no law backing you up. And if anything happens, how do you solve that, the issues that will arise from that kind of scenario? So for us, it was a big error. I don't know if it was inadvertent or how we came to having the situation that we have currently. There are a few other issues I think that we should have looked at. They came from the Civil Aviation Act of 2006. I know the airlines have raised issue in relation to advance payments for arising from liability for carriage, damages arising from air carriage. For instance, the Montreal Convention of 1999 has modified and applicable to domestic carriage requires airlines where there's an accident or bodily injury to pay an advance payment of $30,000 within 3 weeks. I mean, 30 days rather. And most of the airlines have argued that the convention itself, although it provides for advance payments, did not mention an amount, and it did not also put a timeline for the payments. And putting that amount and timeline, I know it's a big issue both for the regulators, for the people who are asking for the compensation, and the airlines as well. I think the SCA, the regulator should have looked for a bit of a flexibility in relation to that, still maintain the requirement for advance payment, but give some bit of flexibility to work around that. There's also the issue of the law included liability for damage caused on the surface. I think Mr. Chukwuma's presentation would have talked about it if not for time. And that itself is a good innovation. It comes with its own positives, but the airlines will look at it and say, look, it's going to increase our insurance premiums, for instance. And it'd be good to see how, as we start implementing the law, how that affects the airlines and their businesses. Those are, for me, some of the things I can see affecting arising from the law itself.
Well, that's very good, Mrs. Nebuna. You've indeed done your work on this, on the Civil Aviation Act 2022, to have identified these shortcomings. So now I'll move next to I'll go back to Mr. Daly. Mr. Daly. Yes, Mr. Daly, and now I'm going to, looking at it from a business perspective, are these innovations that we've highlighted likely to have a positive impact on the operations of airlines and other allied businesses in the aviation sector?
When you talk about impact from the point of view of regulators vis-a-vis the airline operators, regulators are on one side, airline operators are on the other. The regulators are there to ensure principally oversight over safety, security, and compliance, general compliance with regulatory provisions and the statute. The airlines on the other side are interested in profits principally. They will respect as much as they can or allowed to the provisions and regulations and statute. So it depends on where you're looking at it, from which perspective. Of course, from the perspective of the regulators and us lawyers, the Act is of great help. But from the perspective of the airlines, you will find that there will be a lot of criticism. Criticism particularly to do with the issue of the payment of the 5% and how it's implemented and enforced. Criticisms, of course, we also have the issue of the exchange rate. The recent challenge, it's a major, major challenge in terms of where you talk about asking airlines to make payments in US dollars, and yet tickets are earned or paid for in Naira, the conversion, and yet the regulators will be asking for certain amounts and certain percentages and trying to enforce those amounts, not taking into cognizance the challenges that the airlines are having, apart from the issue of collection of funds, remittance, and so on. And then generally, when you even talk about this 5% payments, remittance that have to go to the authorities, to the NTA and so on, which will be shared. What is the 5% for, and is the purpose for which the 5% paid, is it met? And that's what the airlines will ask time and time again. So it's been over the years, it's been a real thorny issue between the airlines and the regulators. You collect this money and you enforce, but yet when it comes to our challenges, which involves methods of payment of these funds, you're not helping us. CBN is often said not to be encouraging in terms of how airlines under the BASA are to remit their funds. At the time the funds were collected, the exchange rate was a totally different figure to what's the current exchange. And then CBN turns around and says, you know, you can change the money on the open market at a rate that is maybe 2 or 3 times the regular rate. What are the regulators doing about this? How are they supporting the airlines in this regard? But yet all they're concerned about is collecting the money. So these are the arguments that are being articulated from all sides. So when you talk about having this statute, yes, you have this strict statute, but in terms of the effective implementation and the practicality of its enforcement, you have these many challenges that occur. And that is really where the issues are. We can have all these statutes, we can have regulation, but then the issue is how do you sort of resolve the challenges that occur out of it. Now, there's one point I wanted to make, and I don't know whether it's the time for me to make it. When my colleague Chinasa Inegbuna spoke about the 30 payment of the advance payments for the...
Yeah, you can, in 2 minutes, you can do that.
Yes.
Yeah.
So very quickly, yes, it's a challenge. The airlines tend not to pay the $30,000 within the 30-day period. But there's a case that in which the courts have stated quite clearly, Court of Appeal stated quite clearly that the airlines are required to pay the $30,000 within the 30 days. Otherwise, they would be liable to payment of interest. And there are a series of cases that sort of confirm this at the Court of Appeal. The authorities can be made available. So in essence, the courts have enforced that provision and viewed the issue of the payment within 30 days as sacrosanct, meaning that they must pay within the 30 days, otherwise they'll be liable to pay interest. And I believe the interest rate was at the rate of 21% per annum for late payment. Thank you.
Okay, thank you, Mr. Daly. Now, my next question will go to Mr. Chukwuma. Mr. Chukwuma, yes. Now we've listened to, I know some of this next question I want to ask you, the answer may have come from some of the responses from you and from the other panelists, but I'll still ask you nonetheless so that you can air your thoughts. Now, the question is, what are the challenges likely to be experienced by the regulator and the regulated in the implementation of the innovations introduced by the Civil Avaiation Act 2022? I know Mr. Dali, in his response, has answered giving some insight into this, but I want you to tell us your view on this.
Your question is the resistance. Sorry, I didn't quite get your question.
Yeah, the challenges likely to be experienced by the regulator and the regulated in the implementation of innovations, of these innovations.
I don't see much challenges other than what has been pointed out. The greatest challenge for us really is in the new method of collecting the 5% charge. We recognize that it's going to disrupt facilitation. It's going to, and that is the reason why it was put in the 2006 Act that it should be part of the ticket payment, so that the passenger does not pay twice. It's not burdened by coming to pay 5% and then coming to pay the airfare. So once the passenger purchases the air ticket, he has already automatically paid the 5%. Some of them do not even know. But then we had a problem with remittance, and the amount was getting humongous, and was beginning to impact even our own ability to effectively oversight. So we have to do this. We know that it's going to create problems, but it's something that we are going to have to work with the airlines to solve. Right now, we have what we call a tripartite agreement. Some of the airlines have keyed in, where the money is automatically sent to NCA by the bank. The agreement is between the bank, NCA, and the airline. It's done every month. Every month, the reconciliation is made. Once the figure is agreed, automatically is paid. So it has reduced current indebtedness. It's not growing. The indebtedness from non-remittance is not growing. It's actually reducing because of this tripartite. So what we intend to do is that any airline that is in the tripartite arrangement will, of course, receive our delegation to go ahead. But then we will still have problems with those who are not.
Mr. Chukwuma, I don't think we can, I can't hear you. I don't know if any other person can hear you.
Sorry, can you hear me now?
Rafiq, we can hear him. I can
Okay,
hear him.
Okay. Yes, I can hear you now. I can hear you now.
Okay, I was saying that the major challenge we see is with the 5%. We do not see challenge elsewhere, but the 5%, because it's going to disrupt burden. And there's a turnaround time for all airlines. It's going to extend it, because what it means is that if we have to collect the money ourselves, we either at the ticketing counter, when you buy, we take our 5% from you, or at the boarding gate, where we ask everyone to see the ticket or to know whether the person has paid 5%. It's going to be disruptive, and it's going to reverse the gains of the 2006 Act that gave it to the airlines to collect. But I'm saying that we are already thinking along the line by what we have now on the tripartite agreement. Any airline that has keyed into the tripartite agreement will be delegated and continue as usual. But we'll still have problems with those airlines who are not yet on the tripartite platform. I don't know if I have time to correct one impression from what Chinasa has said about the $30,000. The provision is that it is the Naira equivalent. It's clear that the advance payment is the Naira equivalent of $30,000. Okay. It's not to be paid in dollars. That advance payment is the Naira equivalent of $30,000. That's the provision. So the scarcity of foreign exchange will not, and it is stated there that it is to address immediate family needs. And you see, we must realize that these are people who are in trauma. Somebody has died. And so I think this is the least we can do. And we have removed the forex scarcity challenge by saying Naira equivalent of $30,000. So we paid within 30 days. I think the airlines can do with that. Thank you.
Oh, okay. Thank you, Mr. Chukwuma. Though I don't know if Mr. Dali will agree with that, but I need the exchange rate, and well, let me leave it at that because of time. So let me go to the next question. Next question is for Mrs. Bunam. Yeah. Now, Mrs. Bunam, how does the Civil Aviation Act 2022 impact on Nigeria's obligations under existing international aviation conventions and protocols? I know Mr. Chukuma has talked on that, about the domestication of these conventions and protocols, but you can still let us have your views on it.
Okay, in terms of, just before I mention something, I just wanted to also add that in relation to the advance payment, my issue is not actually whether it's dollars or naira. You know, if you look at the language of the convention itself, it said death or bodily injury. You know, bodily injury can be interpreted as anything. And if we read, you know, international cases that have been decided in American courts, English courts, anything can constitute bodily injury. I would have thought that the law would have maybe made provision for timeline, but given some flexibility in relation to determining amount, whether in Naira or USD. You know, I felt it would have been a little better approach. Yes, the convention itself is drafted in that manner, but if we look at the convention, it did state amount, and because of that language, bodily injury, for death is clear, but when you have bodily injury, T falls on somebody and the person is scalded, you know, some courts have said that bodily injury. So you're going to pay somebody $30,000 for a hot cup of tea spilling on you. So that's actually the angle I'm coming from. Now to your question, Rafiq, the Act of 2022 actually domesticates 3 new conventions. I think Mr. Chukuma has listed them. The obligations are clear. Of course, they are international obligations. And once we domesticate it, we had ratified them many years ago, but we are just now domesticating it, making it applicable as part of Nigerian law. Once we've domesticated it, it's now an international obligation for us to adhere to those, to the provisions of those conventions. The new conventions are very important conventions, and you know, in line with how safety is now on top, particularly in respect to terrorism acts, and you know, people trying to do some certain things in relation to with aircraft and airlines and all that. So the 3 new conventions are really important conventions, and they are great additions to the law. Now we can, you know, really apply the obligations contained in those conventions. The other conventions, of course, Nigeria has been part of it. Recognition of rights in aircraft has been part of our law since 2016. Cape Town, Montreal, those ones we have been implementing since 2016. So our obligations on the new conventions will now take root, and I think they are great additions to the conventions that have already been included in the law. But before I stop, I noticed a question or a comment by a participant saying that the AIB has been moved to the NSIB Act 2022. I know that that act was proposed. You know, they are building it to liken it like the NTSB in the US, taking care of all of transportation, civil transportation investigation. But I'm not aware that that law has been passed. I'll go back and confirm, but the last I checked, it hadn't been passed. But if it's been passed, that's fantastic. It gives the AIB the legal backing that they really need to perform their role.
Okay, thank you. Thank you, Mrs. Nebuna. So now let me go to the final question. Because of time, we just have about 5 minutes before we go. So the last question is for Mr. Chukuma. I know you said that this act have consolidated civil aviation regulation, all the powers in the NCAA. So now, would you want to tell us if the NAMA, for instance, and the Federal Airport Authority of Nigeria, if they cannot exercise any form of regulation over civil aviation in Nigeria anymore?
The answer is no, they cannot. They never should have. They never should have, because That led to a finding against us in the ICAO audits. They never should have. But it is understandable because their establishment acts predated the 2006 Act. So those old acts had some regulatory powers. But like Mrs. Nebunan said, the review was done at the same time. So all those offending clauses have been removed. And to make sure that in future, nobody sends us back to where we came from, we have included our section 8, subsection 3, which says, notwithstanding the provision of any other law, the NCA shall be the sole regulator of civil aviation in Nigeria. So that has taken care of it. Well, I don't know whether I can chip in 1 second. With respect to AIB, as Mr. Abraham pointed out, the act was indeed passed. It was indeed passed. The multimodal accident investigation act was indeed passed, but was not assented to because there were a lot of objections. So it's gone back to the National Assembly. What I do not know is that whether the National Assembly has once again passed it. I don't know that. But it was indeed passed at the same time, but the president did not assent to it because there were too many objections. Yes, thank you.
So I think at this juncture, this will be a proper time to close the curtain on this session. Before we go, I would like to
take questions, Rafiq. Maybe if there are any questions from the audience, I don't know.
Yes, I've looked at. Okay, I think there's no question from now, but from what I can see, but I think a lot of persons, like 2 persons, have indicated interest in having Mr. Chukwuma's slides, like I said earlier. Mr. Chukwuma, people have indicated interest in having a copy of your slides. If you can make them available to the committee, then we can give them out to anybody who's interested in getting them once they reach out to us. We appreciate that.
I'll do that.
Okay, so I don't think, let me see. Okay, there's no, okay. What somebody asked, what are the 3 new conventions that have been domesticated? Mr. Chukwuma, please, if you can.
I can actually just read it out from the law. I'm looking at it. So you have the convention for the, you have the sorry, hold on a minute. Convention for the suppression of unlawful acts against safety of civil aviation, 1971. You have the Convention of the suppression of unlawful seizure of aircrafts, 1970, and the Convention of the marking of explosive for the purpose of detention, 1991. They are all contained in Mr. Chukwuma's presentation. So when he shares it, the new ones are highlighted, yes.
Okay. So thank you, everybody. Thank you, Mr. Chukwuma. Thank you, Mr. Dali. Thank you, Mr. Nebuna, for taking time out of your busy schedule to honor our invitation, especially Mr. Dali and Mr. Chukwuma. For Mr. Nebuna, it's your session. It's your session, but I will also thank you. It's been a good session. You people have done justice to this topic, and I'm sure that everybody that participated have learned 1 or 2 things from the discussions, from the points you've made. I appreciate each and every one of you. But before I sign off, I think I'll leave the closing remarks to Mrs. Nebuna, the chair of the Civil Aviation, of the Aviation Committee of the NBA section of the Death Law. So it's actually a session. So Mrs. Nebuna, please, the closing remarks.
Thank you, Rafiq, and thank you. My special thanks go to Mr. Emmanuel Chukwuma and Mr. Jibola Dali SAN. I know this has not been easy. I'm really, really grateful for you coming on this webinar to share your knowledge and increase the awareness of how the aviation law practice works. And thank you to our audience, everyone that has joined. I'm really grateful for taking out time to spend 1 hour with the NBA-SBL Committee on Aviation. And I thank the SBL Secretariat as well for all the background work, back-end work, and making everything go smoothly. Thank you, everyone, and have a wonderful rest of your day.
Okay, thank you.
Thank you. Bye.
Happy New Year. Merry
Thank you.
Christmas in
Bye-bye.
advance.
Bye-bye, everyone.
Bye-bye.